Hi, everyone. Thanks so much for joining us. I'm Rachel Fazio. I'm an attorney with the John Muir Project, and we are here today to discuss the Fix Our Forest Act, which has been introduced and passed in the House and is in the Senate, has made it through the Ag Committee, and has not made it to a floor vote yet. And we are hoping to prevent that from happening. So I just wanted to give a brief intro of the Fix Our Forest Act and why it is such a bad bill before we get into the specifics of this webinar, which is to discuss the litigation reform section in the Senate bill, which will unfortunately preclude enforcing environmental laws against any logging project. But first of all, we'll just talk about the fact that FOFA is a logging bill. It is not something that is going to fix our forests. It is something that is going to increase logging and make it much easier for the government to do that without any oversight, any public input. The act creates two new categorical exclusions. Categorical exclusions are projects that are deemed to not have the potential for any significant environmental impact and therefore do not require environmental analysis prior to them being implemented on the ground. Currently, there is a 3,000 acre categorical exclusion in place that the Forest Service often uses for fuel reduction or so-called forest health projects. They want to increase that to 10,000 acres, which I believe is 3 times the size of Golden Gate Park. I mean, it's a huge area, massive impacts, and they are treating it as if there would be nothing significant about doing that. There aren't any restrictions on where they can log. Sorry, got a frog in my throat. And basically, the forest plan would govern what they could do on the ground, but most forest plans do not have enforceable provisions that would make the project be less impactful. In addition to that, they also have included an emergency exemption section in FOFA, whereby any agency head could declare an emergency and proceed with a logging project that would otherwise be covered by doing an environmental assessment or an environmental impact statement. But since there's an emergency, they would allow the logging to proceed prior to or during the preparation of any environmental analysis, thereby making it really, useless. You could write all the comments you want, but the trees will be gone before they even make their decision. So, and before you could even, I mean, you could go to court on the emergency exemption. People have done that in the past. And, it's basically the luck of the draw whether you're able to stop it, because agencies have deference. And if an agency manager is saying there's an emergency, the courts are a wee bit reluctant to stop projects. So that's the fun new stuff that's in FOFA that will promote logging. There's also the litigation reform section, or like we like to call it, the litigation restriction section. And in addition to what we're going to talk about today, they also are trying to reframe the standard for getting a preliminary injunction, which is a way to stop a project or pause it while you're in court. But in the past, the PI standard, as it's known, is basically like a sliding scale, and there's 4 different factors that the court weighs, including the public interest, harm to the plaintiffs. And what the FOFA does is it basically tries to put most of the weight on public interest and makes a very strong assertion that anything you do that you're claiming is going to prevent wildfire is the most important public interest. And so if you're saying that as an agency and a plaintiff comes in and tries to stop a logging project, they're trying to rewrite the public interest standard so that you can't win. So anyway, that's the fun that is FOFA. And what we're here to talk about today is another part of the litigation reform section, whereby they are limiting the statute of limitations to file litigation. But as Katie will tell you, because of the way it's worded, it's actually much worse than that. So without further ado, Katie, please take it away.
Thanks. Jen, do you want to go ahead and start the slides? So I'm going to give you a fair warning. I'm breaking all the rules for PowerPoint slides, and this is going to be very text heavy. But I think it's necessary to see the language, and because we'll step through it together. I've always kind of regarded statutes and a bill like FOFA as a potential future statute, kind of like perverse poetry. You have to kind of study the words and the way they're arranged to really study the meaning of the poem. Before we dive into this, I want to talk about the current governance of our environmental laws. So to really understand how this provision changes things, we have to understand the current legal landscape. Most of our civil laws are governed by what is called a statute of limitations, which is a period after an event that one has to kind of file a lawsuit for relief. For federal agency decisions on public lands, things like logging projects for failing to comply with laws like the National Environmental Policy Act, the National Forest Management Act, the Wilderness Act, it's 6 years. And so the Fix Our Forest Act proposes to severely limit this. So you see here, we're going to be focusing the section in FOFA, and this is the Senate version, section 131C. The limitation on claims is kind of restricting this statutory limitation, the statute of limitation even further. So it bars or prohibits a claim for a covered agency action, which is defined in the bill as projects and NEPA documents associated with that project, unless one of two conditions are true. And we're kind of going to look at both of these provisions. But before we do that, before we kind of take this, dive into kind of these definitions, there's one other piece of background you need to know that's not mentioned in the Fix Our Forest Act, but is really fully implicated in how this provision will operate, and that's the Administrative Procedure Act. The Administrative Procedure Act, it governs agency actions from the rules that agencies promulgate to the decisions that agencies make. It is the law that allows citizens and organizations the right to seek judicial review when agencies fail to comply with our environmental laws, such as the National Environmental Policy Act, the National Forest Management Act, and the Wilderness Act. And in order to bring a lawsuit under the APA for failing to comply with these environmental statutes, there must be something called a final agency action. Commonly, that's when a decision is signed. For environmental impact statements, that would be the record of decision. For environmental assessments, that would be the decision notice and finding of no significant impact. And for categorical exclusions, that would be what agencies call the decision memo. And this makes sense because if the agency hasn't yet made a decision on a project, there's time for the agency to consider environmental impacts. They really haven't failed until they've made this decision. So it would be really speculative to go to court and say the agency has failed any of these laws before it even issues a decision. The decision on the project is the final agency action, and that is the event that triggers the earliest possible date that one can sue under the environmental laws because of the Administrative Procedure Act. Okay, now I'm going to overload you with text. Don't read all of it. Jen, if we can move on. Thanks, Jen. So don't read all of it now. We're kind of going to step through it the way I tend to like stepping through legislative text. The first is kind of understanding the defined terms because bills and statutes are going to operate by the terms that that Congress has defined. And those terms I've actually highlighted in a salmon color here. The fireshed management projects are basically, they're different types of logging and a little more. This is defined much earlier in the Fix Our Forest Act. It could be, and these are quotes coming from the Forest Service, so, don't take them for what they're worth. They're calling them hazardous fuel management activities, fuel breaks, removing hazard trees, dead trees, or dying trees, basically removing trees to thin a forest stand, what they call treatments to address insects, disease, or control vegetation, vegetative competition. They have something for wet meadow, floodplain, or riparian restoration activities that, quote, increase wildfire resistance. Forest stand improvement activities to kind of protect the life and property from catastrophic wildfire, or a combination of any of these activities. That is what a fireshed management project is. And kind of before we kind of dive into the meat of number one, I think the linchpin of how this is going to operate kind of focuses on the other thing they've defined, which is agency document. An agency document I put into the right column for you. It's going to be the definition that's the linchpin to creating this loophole. So you see under agency document, they've listed there are four things that can be an agency document. The first is it's a record of decision. The second is decision memorandum. The third one is an environmental document, which is further kind of defined in the statute as an environmental impact statement, environmental assessment, or a finding of no significant impact, and then programmatic environmental documents. So that governs kind of a plan or a group of related actions that are covered by one environmental impact statement or environmental assessment. And really, if you look at this list, there's a really big difference between the first two agency documents and the last two agency documents. And the first two agency documents, those are decision documents. So those are the decisions from which you would be the earliest possible date that one could sue for failure to comply with an environmental law under the Administrative Procedure Act. Those second two documents, those are analysis documents, and they're often generated before decisions. So the Fix Our Forest Act here, if you look at subsection 1, it limits, so basically in both scenarios, the Fix Our Forest Act limits the time that you can bring a lawsuit to 150 days. And if 150 days starts after a decision, that's already problematic for a host of reasons. Often when we have an agency decision, organizations or individuals will submit a Freedom of Information Act request to kind of understand what the agency considered. And while the agency must respond to one of these requests in 20 working days, I think we all know those responses are never timely. For Endangered Species Act suits, there needs to be a 60-day notice of intent to the agency. So if you start kind of adding this up, it really, if the 150 days starts at the point of an agency decision, it only gives you a handful of days to find an attorney, and attorney's going to want to take time to review their liable claims. But what makes this really problematic is that in both scenarios, it's when this 150-day clock starts. And that is where the term agency document becomes really important. So the first scenario, which is the one you see before you, I kind of put at the bottom, I tried to make a timeline for the worst case scenario. So that's kind of what you're looking at. The first scenario is when the agency chooses to notify the public of a NEPA analysis of an environmental impact statement through the Federal Register. So that is kind of the first thing you see on this timeline. If the agency has chosen to publish in the Federal Register, then they're obligated, I think, when the text of this says, not filed 150 days after the date of publication of a notice in the Federal Register of agency intent to carry out this project. So I see that the plain reading of that is the agency has to publish a notice that they're going to carry out the project that's outlined in the EIS. And if you see at the bottom in the green square, I put a question mark after decision because this notice of intent, it could be the decision. And if it is the decision, the 150-day clock starts when there's a final agency action. And this is the best case scenario, as that one has 150 days. But you'll notice in this provision that it actually doesn't say decision, it just says intent to carry out the project. And so an agency could interpret the notice of intent to be just a notice that they plan to carry out one of the alternatives that they've presented in the environmental impact statement or environmental assessment without naming that alternative, which also could be understood to not be a decision yet. So in this case, the 50-day clock would start running before a decision. And if the decision actually follows more than 150 days later, it would be legally impossible to bring a suit because the time period allowed to bring a suit under the Fix Our Forests Act will have no overlap with when the suit can first be filed under the Administrative Procedure Act. And this is kind of what I've tried to highlight with this timeline. So if you file, like if the notice to carry out the project precedes a decision, and you know within that 150-day window, it will be thrown out in court. Like it would be very likely thrown out in court under the Administrative Procedure Act because it's not yet a final agency action. But if you file after the final agency action and that 150-day window has already run because a notice of intent has already been filed, the suit will be thrown out using this Fix Our Forest Act provision. So this is one of two scenarios, but the second scenario is actually a little worse. And Jen, do you want to give me the third slide now? Thank you. So in this case, you see agency documents, so it still considers these analyses document and not the decision documents, but it also has something called the earlier of basically 2 dates. So the earlier of 2 dates means that the 150-day window is going to start running at the notice or publication of the agency document. But the agency document means the analysis, the agency document means the analysis, the environmental impact statement or decision. And because like environmental impact statements and environmental assessments precede decisions, the EIS or the EA is going to actually is what is going to trigger the 150-day clock in this scenario. So if a decision is published after 150 days, you have the same result as scenario one because the time periods for a lawsuit under the Fix Our Forests Act and the Administrative Procedure Act are not overlapping time periods. Which means, again, if you file within the 150-day window on this timeline, your case will be thrown out under the Administrative Procedure Act because it's not yet a final agency action. But if you wait until the final agency action and it's after this 150-day window, the suit will be thrown out using this FOFA provision. So with that, I would like to turn it over to the next person.
All right. Thank you very much, Katie. I think that's me. So I'm Dr. Chad Hansen. I'm a forest and fire ecologist with the John Muir Project. And I'm just going to talk briefly about some really nightmare scenarios that would be absolutely possible if this language if the Fix Our Forests Act passes. Okay, so as Katie mentioned, the act as written in this section, it puts environmental groups in a catch-22 situation. You can't file before the 150 days. And if you file after the 150 days, you're basically thrown out of court too. This is not just a limitation or basically a nullification of the National Environmental Policy Act. The language that Katie quoted earlier said, notwithstanding any other provision of law. It applies to every single federal environmental law on federal public lands with regard to these so-called forest management projects, which again, those are euphemisms for logging. It can be any kind of logging. So bear in mind, in Section 106 of the Fix Our Forests Act, there are no restrictions, no limitations whatsoever on the age of the trees that could be cut, the size of the trees that could be cut, the species of the trees that could be cut, or the percentage of the trees that could be cut. In other words, they could go in there and log old growth trees. They could target them. They could clear cut any forest at all. No restrictions whatsoever. All they have to do is say the magic words that they're doing it for fire management or forest health, etc. With a wink and a nod. Okay, so let me just explain a couple of scenarios that could actually play out here, because the way it's written, as Katie laid out, it would prevent environmental organizations from going to court to enforce any federal environmental laws, National Environmental Policy Act, National Forest Management Act, forest plans, right? Endangered Species Act, the Wilderness Act, Clean Water Act. So imagine that if this passed, this bill, the Forest Service could propose a logging project in a giant sequoia grove, which they're doing right now under existing laws, but they could go far, far further. They could go and they could cut down old growth giant sequoia trees, put them on logging trucks and send them to the logging mill. And even though it's a violation of the current forest plans to cut down old growth giant sequoia trees, there's nothing that environmental plaintiffs could do about it. The laws would have been essentially nullified by these provisions in the Fix Our Forest Act. So that would be something that you couldn't do anything about that. The Forest Service or the BLM could plan a logging project, a clear-cut logging project in a wilderness area. They could punch a logging road into the wilderness area. They could clear-cut vast swaths of wilderness, and environmental plaintiffs couldn't do anything about it because you can't file suit before the 150 days. And if you filed suit after the 150 days, you'd be thrown out of court under this language. So a third scenario, they could propose and plan and implement a logging project in any endangered species habitat, and without any repercussions whatsoever. Not Clean Water Act, not Endangered Species Act, not Wilderness Act, not National Forest Management Act, not the National Environmental Policy Act. All those laws would be essentially nullified if this language became law. So, the consequences of this are profound, to say the least. And I just want to note here that none of these consequences and the true implications of this loophole, it was never mentioned anywhere by the U.S. senators who promote this bill, or the U.S. senators who voted it out of committee. So with that, I will turn it back over to Rachel Fazio.
Thanks, Chad. Okay, I am going to try to share my screen, and we will see how that goes.
While you're doing that, Rachel, I just want to follow up on a point that Chad made about the Wilderness Act. Like a lot of the Fix Our Forest Act makes exceptions for wilderness areas, but kind of the point that we're trying to highlight is because of the timing and when you can file suit, even if they didn't follow the Fix Our Forest Act, it would be almost impossible to file. It would be very difficult to file and to get around this stuff, making an argument that they have violated the Wilderness Act. So even though like the wilderness isn't implicated in some of these categorical exclusions, if the agency just was either like maliciously or ignorantly included wilderness, like these provisions would still like really complicate and perhaps stop any enforcement of the Wilderness Act. Okay, sorry.
Thanks, Katie. All right, let us see if you can see my screen. Can you see my screen? Now I'm frozen.
It seems to be loading. There we go.
Okay, is it?
No, you need to make it the slideshow. Yeah, start. Yep.
Okay, so now we're looking at US Code 2401A. Okay, so now that we have, horrified you with the possibilities, you may be thinking, but that could never happen, right? No judge would allow that to happen. And, I felt the same way when I was reading through this and we kept going over the provisions and saying, could that really be the case? But if you went to court after the 150 days, the court would likely engage in a practice to try and ascertain what Congress actually meant. So they would be diving into the legislative history of this provision and trying to figure out, did they really want to bar or prevent public interest plaintiffs from bringing a lawsuit under any of the laws, ESA, Wilderness Act, NEPA, if they didn't file before 150 days. And going through the codes that exist and what has been said about FOFA in hearings and on the floor, where there was very small amount of debate, I am going to say they would definitely decide that Congress meant for no lawsuits to be able to be filed, for these laws to no longer be able to be enforced. So we're going to go back in time 70 years. This is a provision of the United States Code, which allows for there to be 6 years for a civil suit to be filed against the United States. So this means prior to FOFA, with regard to logging projects, any plaintiff has the ability to bring a lawsuit within 6 years of the decision being made. As it says in this, right of action first accrues. So that goes back to what Katie was saying about the Administrative Procedures Act and there being a decision that is ripe for challenge. You also, in the administrative law world, you have to exhaust your administrative remedies. A lot of these logging projects, there's a decision. Sometimes there's an appeal that's allowed or an objection that's allowed after that decision that gives the agency the chance to modify things to try and avoid litigation or to comply with laws that they violated. So the right of action first accrues after all of those precursors to filing have been satisfied. And this has been the law for 70 years. And what FOFA wants to do in the best case scenario is shorten 6 years to 150 days. Going back to one of Katie's timelines, right? So let's pretend that they actually did do a decision. They noticed it, the 150 days it runs after the notice. That's 5 months as compared to 6 years. And when you are a small environmental organization, you have limited funding. You don't necessarily have lawyers on staff that can take the lawsuit, or maybe you do have lawyers on staff, but they're already involved in several and you need to get outside counsel. 150 days to try and review all the documents, try and get additional documents through the Freedom of Information Act, as Katie was talking about, getting a lawyer that has the time within 150 days to write a complaint and file it to get up to speed on the case. It's almost impossible. So under the best case scenario, it's unlikely. But under the worst case scenario where you're filing after 150 days, the court is going to say, well, does Congress know how to articulate when they want the statute of limitations to start running? And they'll look back on this code that's been in place for 70 years and say, well, of course they do. Look, let's just read the words. Every action against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. So when we're talking about logging decisions, we're talking about everything being satisfied. The first day you could possibly go to court, that is when the statute of limitations starts running. And they'll look at the language in FOFA, see if I can actually advance my slide. What happened there?
That was the last one. You got to go back rather
Oh, backwards. Okay.
Yep.
So they'll look at the language in FOFA and based on connecting all of the dots with what is an agency document, what does it cover? Oh, it covers environmental impact statements in addition to decision notices. So they will read this and they will say, well, it says 150 days, that is the earlier of the date on which such agency document or application is published. The EIS was published, intent to prepare an EIS was published on February 1st. Therefore, 5 months later is the date, but the EIS isn't even done. Under other laws in Congress, they have ordained that agencies must complete an EIS in 2 years. And here we're supposed to be filing a lawsuit after 150 days of the notice of intent to prepare the EIS. So the court's going to look at this and say, well, yeah, I mean, obviously they say notwithstanding any other provision of law, that includes the code that I just showed you. And it's 150 days, period. There aren't any exceptions. Another thing they'll probably look at is the House version. Should the Senate version pass and the House accept the Senate version and it becomes law, the House version actually has a way out of this. The House version was 120 days, Senate increased to 250, but they say in the House version that plaintiffs are not prevented from filing a lawsuit after the 120 days, so long as they participated in the administrative proceedings regarding the project, submitted comments during public comment period that were sufficiently detailed for the agency to be on notice of the issues that they seek judicial review for. So someone in the House understood that the language above about being barred based on when an agency document is noticed was problematic. And they actually put a paragraph in there that preserved the 6-year statute of limitations for parties that are actively participating in critiquing and commenting on logging decisions. So the court, if the Senate version passed, which would be most likely because if the Senate passes it, it will go to the House, and in order to avoid having a conference committee, the House would simply have to accept the version passed by the Senate, and then it would become law once the president signs it. So that is a very likely scenario. The court, if you went to court after 150 days and were like, but no, they would be like, but hey, there was a version of this that existed that actually maintained the 6-year statute of limitations for people who actively participated in logging project comments. Sorry, Charlie. The Senate version clearly didn't want that because they did not include that that provision in there. You are out of luck. So with that happy news, we can turn it over to Jen to tell us where things are at in Congress and what we can do to fight this.
Thanks. Yeah, so Rachel kind of gave the overview before we started, but last January, before the ashes even settled on the LA fire, the House passed the House version of the Fix Our Forest Act, and the Senate introduced their version last April. And then in October, they had a markup where 6 of the Democratic members voted it out of committee. So this is the version we are currently dealing with. So the call to action is to call your senator. The phone number is 202-224-3121 and ask them to oppose S 1462. Yeah. Thank you. So yeah, again, the ask is to call your senator to have them oppose S 1462. Again, the switchboard number is 202-224-3121. We will be updating our action alert that we can send around with a webinar recording later if you'd like to do it that way. It is better when you call though because an intern does actually record it into a spreadsheet that is then reported to the senator, whereas emails can kind of get lost in staffers' inboxes. So if you want to do both, go to town, but we really do ask that you call your members, your senators. And it's unfortunate because the word on the Hill is that they're waiting it is kind of odd. They claim they have the support is there, but they haven't called it to the floor for a vote yet. So ultimately, we're hoping it dies in the Senate this year and is not resurrected next Congress. But the word on the Hill, unfortunately, is that, we're going into fire season. We've had a pretty significant drought this year across the country. So they are waiting for a possible repeat of LA in a Western town, which is really unfortunate. There is bills out there that you can support instead. S 3609, the Community Protection and Wildfire Resilience Act, which would put money into home hardening and defensible space and better evacuation routes, which is the proven technique to prevent our communities from burning down. This isn't a West Coast issue. This would be kind of making its way across the country because these are fire adapted ecosystems. It's a very natural and necessary process. And the way our agencies go about them really actually, for lack of a better phrase, pour gasoline onto the situation. So yeah, we're happy to answer questions. There's a couple in the chat unless y'all have anything else you would like to go over before we open it up. You're all muted, but
Yeah, I think we can go to Q&A.
sweet.
Yeah,
Go
I'll
ahead.
just say, sorry, I answered one. Paul had asked about the CBO score, and I just checked on congress.gov while we're finishing up here, and they say as of today's date, there hasn't been a cost estimate received for the Senate Fixer Force Act.
I believe the House was 0, but I think that is also intentional, right? A lot of these bills that we see, especially coming from Republicans, have a CBO score of 0 because they don't want any number attached to it. And that's been kind of a lot of the gripes that Democrats have had, unfortunately, rather than the issue at hand, right? We should be working to make communities firewise by working from the communities out and not the wild in if we actually want our communities to be firewise. And unfortunately, well, we will have to put money into that, right? FEMA did a study in 2018. For every dollar you invest in home hardening and defensible space, you save $3 to $4 down the line in disaster recovery. Nobody wants to talk about this. There is, again, this one bill, the House number, if you're also interested in calling your House members, is HR 582. The Senate is S 3609, the Community Protection and Wildfire Resilience Act, where we can put our money where our mouth is and actually get communities fire wise. We have to take responsibility for the fire adapted ecosystems that we live in, and that is where we should be starting, not in the backcountry where we will just be making them burn hotter and faster towards communities. So it's really unfortunate that they're playing with such a scary topic. I mean, I was on the 101 during the Thomas Fire. I understand a lot of you guys on this webinar live in fire-prone areas. But our agencies in Congress are really barking up the wrong tree. So we would really love it, yeah, if you guys could take a couple minutes to call, and happy to put those in the chat also and follow up. Please feel free to email. Cynthia, I'll read the question, but I'm not. Oh, Katie, go ahead.
Yeah, I was going to say, just to clear, the cost estimate isn't 0. It's they haven't received one yet. So
On the Senate side, I believe the House
on the
they
Senate
did.
side.
Yeah.
Okay.
Yeah, I
Okay.
believe. I could be wrong, but I believe the House one was scored at 0, which is what they were touting.
Okay.
It's no money, but yeah.
And isn't that just simply because in FOFA they do not actually allocate any money for the activities they are promoting in the bill, including community protection and home hardening? So it's really just policy that is changing, but money is not appropriated within the Fix Our Forest Act or anything. So ergo, you can say it costs $0.
Yeah, but as our colleague Steve from ABC, who I believe is on this webinar, pointed out, it will have to come from somewhere, right? So they will be taking it away from wilderness programs, fish and wildlife, things of that nature. It will have to come from somewhere if it passes. So if we want to, again, invest in proven solutions, we should be throwing our support behind S3609 and HR 582, the Community Protection and Wildfire Resilience Act. Okay. So, let's see. I'm not sure, Cynthia, any insights on why groups like the Nature Conservancy and the Environmental Defense Fund support FOFA? Are they not aware of the loopholes? I mean, I've not personally spoken with either of those groups. We have spoken with the Citizens Climate Lobby. You know, I will just put it out there. You're free to go to usaspending.gov and look up the Nature Conservancy. They have received over $500 million from uh, the U.S. Department of Agriculture, which Forest Service sits under, and a lot of that money goes to hazardous fuels reduction projects. So the information is there. Unfortunately, no one's really reporting on this or kind of raising this conflict of interest issue. I can only assume this is why they're in support of, because a lot of they will be receiving a lot of this money. We are hopefully meeting with EDF, if a colleague can put us in touch. But yeah, I just don't have I don't want to speak for Wilderness Watch, but I don't have contacts there. We have attempted to talk to TNC in the past, and it has not been well received, or received at all. We've just been ignored. So yeah, I'll leave that there unless anybody else has anything else to say on that front.
I'll just add briefly that Jen's point about the Nature Conservancy and the fact that they're receiving hundreds of millions of dollars in government grants to carry out and support these sorts of logging projects under euphemisms like hazardous fuel reduction and restoration. That's not limited to the Nature Conservancy. Other organizations that posture as environmental organizations, like TNC, but in practice are something very different, have also jumped on the gravy train, and they're getting large, lucrative government contracts and subsidies to do these logging projects on national forests. They're basically being hired as logging companies. The Save the Redwoods League, for example, is one of those logging companies that is posturing as an environmental group. But that's really what they're doing now, is getting millions and millions of dollars in government grants to carry out logging projects, including in sequoia groves. That would be much, much worse, of course, if the Fix Our Forest Act passed. And they're not the only ones. There are other ones. If you look at the list of organizations that claim to be environmental organizations, some of which actually used to be environmental groups, a lot of them are getting these government contracts, very, very lucrative government contracts to do these logging projects on public land. So they're basically functioning like logging companies now.
Chad, do you want to, someone asked if we're able to speak more specifically on why CCL supports FOFA. We did meet with them. I feel like it was, you could probably give a more polite, yeah, go ahead.
Sure, I'd be happy to. I mean, if we've looked into this quite a bit, we've tried to communicate with Citizens Climate Lobby. What I can tell you is that what they have been promoting, they say that the Fix Our Forest Act will facilitate more prescribed fire on national forests and other federal public lands. That's what they say. They don't use the term logging. They don't say anything about logging, really. If you look on their website, their public communications, they say, oh, yeah, we want more fire in our forests, more fire in our forests. And that either they don't understand the Fix Our Forest Act at all, and they just haven't done their due diligence, which is certainly possible, or they're not being fully candid with the public when they say that, because there's already a categorical exclusion under existing law for prescribed fire. The Fix Our Forest Act wouldn't change that at all. What the Fix Our Forest Act would do is change the law with regard to logging projects on national forests and BLM lands. That's the only thing it would really do is change things with regard to logging and basically close the courthouse doors under the Senate version. And even if even under the House version, as Rachel and Katie mentioned, it's a radical, extreme restriction on the public's ability to comment on and participate in decisions being made with regard to logging projects on public lands. This is a really, really extreme logging bill, but Citizens Climate Lobby doesn't seem, they either don't understand that and certainly don't understand anything about this loophole, or they're not being honest with the public about that, or with the press, or with Congress. Same thing with regard to other groups like Megafire Action that's been promoting this. They are all responsible, and they all should be held accountable for promoting this legislation with all of these provisions in it, not just this loophole that we're talking about today, but the categorical exclusion expansion to 10,000 acres for these logging projects, the so-called emergency provisions that Rachel talked about, and the restriction that Rachel talked about on trying to tie the hands of judges to prevent judges from issuing injunctions against illegal logging projects. All of those are extreme and radical rollbacks and weakening of environmental laws. And of course, as a fire ecologist, a professional fire ecologist, I can tell you that there are dozens and dozens of scientific studies, peer-reviewed scientific studies, stacks of them, most of them by the U.S. government's own scientists, primarily U.S. Forest Service's own scientists, saying that logging does not curb fires. It tends to make fires burn faster and hotter and more intensely. It dramatically increases carbon emissions into the atmosphere relative to wildfire alone. And it tends to put communities at greater risk of wildfire because the fires reach the communities faster and people have less time to evacuate. And it's diverting all the money away from home hardening and defensible space pruning into these backcountry logging projects, subsidizing them. So it's an incredibly wrong-headed approach. No environmental group should be supporting this. But I think for me, the answer is, candidly, that a lot of these groups that are supporting it are really no longer environmental groups, or never were.
Yeah, I would just add too about the Citizens Climate Lobby is they're hearing more. They're hearing from other people besides just like I know John Muir Project had reached out and tried to engage with them. One of their own members kind of understood this, and I chatted with her, and she had a meeting with the highest ups, and they haven't. So it's not like they're not getting this information. They might not know about this particular loophole, but this isn't the only part of the Fix Our Forest Act that's bad, and they know about the rest of that.
Yeah, someone in the chat said that some members are questioning, some CCL members are questioning FOFA and may bring their concerns to leadership. So yeah, please do. We're happy to be a resource if you need help on that front.
Yeah, I think the more leadership hears from their members, the more they might actually listen. I think this one individual kind of hit a brick wall, even though she talked to one of the leaders. But yeah, hearing from more can't hurt. So.
Yeah, and I just want to add to that we've been in communication with a number of people in Citizens Climate Lobby, activists, volunteers, people at different levels. There's some great people in Citizens Climate Lobby at different levels that are not among the highest levels that are making the decisions on this. A lot of the people in the organization at middle and lower levels who are raising serious concerns are being ignored in the organization. We've been doing what we can to get them information and support them. But this decision needs to be made at the top, and they need to make a different decision. They need to go in a different direction. So I want to be clear that like any other large organization, CCL is not a monolith. There's some great people in CCL, but the people at the top are making the wrong call.
Okay, so I'm going to go. There's two kind of similar questions. I'll start with one that's a little less, or hopefully more. Anyways, so there have been significant negative changes in the U.S. Forest Service. How could this impact FOFA? I'm not sure if we have too much insight, but I'll pass it on to maybe Katie or Chad or Rachel to see if they have any insight or.
Actually, before we answer that one, could we take the easier one by Lisa to kind of warm us up for that one? And like Lisa had asked a couple of questions. Can anyone conduct a fireshed management project, or does it have to be a government agency? And is the Forest Service the one that would be logging? So this would be, I would think, and correct me if somebody else has a different opinion on this, but I think this would be like your normal logging project. And the way that works is the Forest Service proposes like what they would like to have done, and they do the environmental analysis for that, and they approve the project, but then they contract the project out to a private company that then comes in, cuts down the trees and hauls them away and takes them to a mill and like profits off of that. So that is like, does anybody think FOFA is going to like work differently? Because that's usually how logging projects work on federal public land.
Yeah, I
Yeah.
think it's the standard logging project is the way it would typically happen. Just they use these euphemisms like forest health and hazardous fuel reduction. But yeah, but it's a straight up federal timber sales program.
Yeah, although I will say, getting into Cynthia's question, that it's possible that with these cutbacks and reorganization of the Forest Service, that may change under FOFA, especially if they're really going to dive into trying to crank out projects if this law passes. Um, and it might become that they would have uh, private timber companies do the analysis themselves and then do the logging. I know there's at least one bill out there, and I'm spacing on which one it is, where they wanted to try and reward. Um, Jen, help me out here. It was, it was trying to basically give the companies that do their own analysis like a break. Um, yeah, it's
And
ringing
not
a bell,
requiring.
but I
Yeah.
can't remember what it
Yeah,
is.
There's too
there is
many
a
bad
provision.
bills.
There
Yeah.
is a provision out there like that, but I will say this is not a theoretical. What the concern that Rachel's raising is not theoretical. It's not what the Forest Service has typically done in the past. But I have personally experienced more than one scenario. It has been the exception, very much so, in past years. But moving forward, if FOFA passed, it could become the rule, where the Forest Service actually contracts out to some private company to do the environmental analysis. And there's nothing that says that private company couldn't be the logging company, or some company affiliated with the logging company. So yeah, it's. I mean, this is a very, very, very dangerous slippery slope. And again, anyone who jumped on the bandwagon with this, they either were misled to a spectacular degree. And look, there's nothing wrong with making a mistake. There's nothing wrong with being misled. It happens to everyone, all of us, including me. But once you understand what's really going on, once you understand that you were misled, you need to change direction. That's on you if you don't.
But as we know, that is very hard to do. Even congressmen and senators who are made aware typically will not take their name off a bill. They will simply just run out the clock and maybe not support it the next term. So, as far as citizens climate lobby, it may be that they're just trying to save face. And so they don't want to reverse their position. Uh, it may be that they are very supportive of Senator Padilla or, Senator Curtis or Hickenlooper, who have done good deeds for them in the past. And so they're not going to change their position because they're, you know, um, supporting their allies, so to speak. So, I mean, I guess you would pretty much have to ask them why, in the face of, the damage that this bill will do to forests and to our climate, that they would still maintain support for it. We could speculate all day.
And I would add that even though like original sponsors and original co-sponsors of the bill can't take their names off of the bill, they can still vote against the bill. I mean, it would be an admission, like a mistake, which like I think is hard to get Congress to admit to. But that would be like they're not committed to voting for the bill even if they sponsored it. But they can't. The original sponsors and co-sponsors can't disassociate from the bill. So.
Definitely. So, another question, can FOFA itself be challenged if it passes? I imagine the answer is no, but I will leave that to the lawyers.
I don't see a path where it can be challenged on kind of the statute limitations that we talked about with the 150 days, because Congress ultimately kind of gets to pick that. I know we had, like, I'll let somebody else weigh in. Like, I'm not sure if it's going to be like a separation of powers issue with like trying to control so much of what the courts do. But definitely, like the statute of limitations, I don't see, or, some of the other provisions that it kind of just allows are like, I think Congress will have chosen at that point, and our choice is to, or our path forward after that would be to try to convince enough members of Congress to change the bill.
Yeah. Is industry ready to step up to this kind of logging increase? What is the capacity like for mills and or export? And can U.S. Forest Service slash BLM cover these kinds of increases with the employment situation that they have?
I can address that. I mean, candidly, the Trump administration has laid off a lot of people in different federal agencies, including the United States Forest Service and Bureau of Land Management. Having said that, most of the people who have been laid off are wildlife biologists, recreation officers, people who basically are doing the good work of caring for public lands and facilitating public participation in public lands and recreation and access to public lands. The people who they're not firing are the timber sale planners and the foresters and the road builders and all of the the engineers, all of the people who are involved in running and carrying out the logging program, the federal logging program on federal lands. Those people are not being laid off. So basically, they're consolidating resources into a subset of the federal land management agencies, and that subset is the logging industry, essentially. So yeah, I mean, if they got this massive additional latitude, basically unlimited latitude, if the Fix Our Forest Act passed, if they got that, they would massively ramp up logging. And we're not talking about small trees and undergrowth, which is what they say a lot of time. Small trees and underbrush. You'll hear that from the supporters of the Fix Our Forest Act all the time. That is an absolute deception and misrepresentation. The typical so-called thinning project on national forests in recent years, it kills and removes upwards of 70 or 80% of the trees in a given stand, including many mature and old growth trees. These are industrial logging projects. And of course, like I said before, the Fix Our Forest Act doesn't preclude clear cutting either. But even if it is so-called thinning, a lot of these thinning projects these days are really close to clear cuts.
I would also add that, like, I'm actually going to, like, during the next question, I'm going to look up the Pacific Northwest Forest Climate Alliance has kind of a page of pictures of what, kind of the euphemisms for logging projects are. And so you can see what a thinning project or a restoration project looks like on the end. And I'm going to look for that right after I answer this question. But I think there's been, after the timber wars of the 1990s, I think, and especially after, because like what happened at the same time of that, like as those wars and the listing of the spotted owl was this like increase in mechanization, and really like the like logging companies and like the pro logging industry did a great job of spinning like and blaming this like dive and like kind of mills and stuff on the owl. What was like really kind of, it was really like more mechanization, and the fact that one guy can sit in a machine and cut down like a lot of trees where it took like more foresters. So I think kind of like that has led to kind of like not only the lost interest, but kind of this decreased mill capacity. And so we're in an era where that hasn't been built back. And I think we're in this kind of delay where if we can keep this stuff at bay, this infrastructure won't come back. But if a law like the Fix Our Forest Act passes, there's nothing to stop that infrastructure from coming back. It just might be like another like 5 or 6 years before like we really kind of start seeing the impacts of this because they'll have infrastructure to handle it.
Definitely. So the rest is kind of more on CCL and kind of speculation. I don't know if we want to really get more into that. I will say I did see, somebody did comment, CCL does not support any senator or rep. It is nonpartisan. I know they do emphasize bills that they support need to be bipartisan. So I will emphasize that the bill we have been kind of plugging as like the alternative to fix our forests that I put in the chat is bipartisan. The Community Protection and Wildfire Resilience Act, introduced in the House by Rep. Huffman, and also in the Senate by Rep. Padilla and Sheehy. If we really want to protect communities from fire, that is where we start, is in and around communities. With that, I mean, we're at the top of the hour. So yeah, if there's no other questions, I think we can end it there. I will put my email in the chat if you guys need any help. Alan, I saw that you asked for some talking points, so we can definitely talk offline to help on that front. But yeah, please let us know if you need anything else. And one last plug, call your senator 202-224-3121 to oppose S 1462. I think we can leave it there. So thanks. Appreciate your time, guys.